10. How do I determine whether someone is an employee or an independent contractor?
Independent contractors differ from employees in two primary ways. 1. They control both the outcome of a project and the means of accomplishing it. 2. They offer their services to the public at large, not just to one company. Problems arise because some workers fall into a gray area, thereby creating the danger of misclassification. The Internal Revenue Service, IRS, provides forms to help classify workers, but sometimes these tests complicate rather than ease the task of classifying workers. Worker classification and benefits rights have gotten much attention in the press of late in light of a noteworthy case. Long-term Microsoft freelancers sued the company arguing that they were, in essence, employees of the company. Their class action award for back benefits and stock options was expected to settle in the $30 to $40 million range. The actual $97 million settlement caught many CEOs, employment lawyers, and human resources managers by surprise and cast a strong light on this issue. Many employers operate under the misunderstanding that they will be protected from the significant penalties of misclassification if the worker asked to be treated as an independent contractor and signed a written contract acknowledging that relationship. In fact, this doesn't protect your company from a charge of misclassification. If you misclassify workers as independent contractors, be prepared to be subject to back taxes, interest, and penalties enforced by the IRS. In addition, you could face workers' claims for unpaid benefits, overtime, and minimum wage requirements through the U.S. Department of Labor, DOL, which has the discretion to impose substantial penalties. You could also be required to pay the company's and employees' share of Social Security and Medicare contributions, income tax that should have been withheld from those employees' wages, and federal unemployment tax. Finally, if the worker is injured on the job, you may have to pay workers' compensation benefits. Note that a disadvantage to independent contractor status is that an individual injured on your premises can sue your company for injuries in a civil lawsuit outside the workers' comp arena. In a civil lawsuit, there are no damage limits similar to those that exist in the workers' comp system. Tell me more. Why would a company want to classify someone as an independent contractor rather than an employee? There are several very good reasons. With independent contractors, you have no obligation to withhold payroll taxes or to pay any portion of the individual's Social Security or Medicare taxes. In addition, rather than sending the person a W-2 showing earnings and taxes withheld, your only tax responsibility is to complete a Form 1099 miscellaneous at the end of the year if you paid the independent contractor $600 or more. You are not required to carry workers' compensation, contribute to an unemployment insurance fund, or offer health, welfare, or pension benefits to independent contractors. Instead, independent contractors are paid only for the time they spend working. Terminating independent contractors is fairly easy to do because the individual is hired for a set assignment to be completed by an agreed-upon deadline. There is no need for coaching or progressive discipline in the form of written warnings or suspensions and no fear of wrongful termination. Arrangements are usually set up so that written contracts between your company and the independent contractor allow cancellation on 2 weeks' notice. Finally, whereas employees are subject to various government regulations, including wage and hour laws, family and medical leave, and illegal discrimination, independent contractor status, when properly classified, avoids most legal restrictions. Sounds too good to be true, doesn't it? As with most things in business, there's a catch. Worker classification is no exception. Now that you know the upsides and downsides of classifying individuals as employees or independent contractors, Tread carefully when determining whether you've got a bona fide independent contractor working relationship. Remember, though, that the IRS strongly prefers to have workers classified as employees rather than independent contractors if there's any doubt at all about their employment status. To determine whether a worker is an employee or an independent contractor, the IRS generally looks at the degree of control you have over the worker. If you, the employer, control, or are otherwise able to control, not only what's done but also how it's done, then the worker is probably an employee. On the other hand, an independent contractor status will more likely be upheld when individuals decide when, where, and how to work, hire, supervise, and pay their own assistants, conduct work at their own office or shop,